Well, hello, everybody. Welcome to the Transparency Tuesday night Delphi coverage. Explosive document drops from the limited appearance attorneys of Richard Allen.
A small Indiana town of just 3,000 people. On February 13th, 2017, Libby and Abby went hiking. The two teenagers were good friends and had the day off from school. The weather was unseasonably warm, but when Libby and Abby did not show up when they were supposed to get picked up, their families began to worry, and they began to search. Then, the next day, the bodies of these two girls were found, both victims of murder. Then, over the course of the next 5+ years, there were no answers, no arrests, just a series of disjointed clues, like two sketches that looked nothing alike, a video of the suspected killer, and a short audio recording of his voice.
All right, guys. Explosive documents here. Again, good evening. The defense motion to correct abstract of judgment and defendant's motion for a hearing on motion to correct error. Well, I made some very interesting posts today in my community section because I am balls deep in with our rights. I don't understand. I mean, how are you on the opposite side of our rights? So this has nothing to do about somebody being innocent or guilty. This is about how is this the United States of America's criminal justice system? It's just not. It's just not. So go ahead and indulge yourself in what I wrote. Basically, we have a civic duty, and that would be murder sheet, and that would be the jurors. They have a civic duty now after this has dropped, in my opinion. So the defendant here, by and through his attorneys, so the defendant, Richard Allen, by counsel, respectfully requests that this court set a hearing on defendant's motion to correct errors. In support of this motion, the defendant states the following, and there's 4 of them. The defendant has filed a motion to correct errors contemporaneously with the filing of this motion. In this motion to correct errors, the defendant requests that the matter be set for a hearing, and based on Indiana Trial Rule 7.6, it requires a party requesting a hearing to file such a request by separate motion. So that was done. The defendant, Richard M. Allen, by counsel, respectfully requests that the court issue an amended abstract of judgment. In support of the motion, defendant states the following, and here are the 4. Number 1, on December 23rd, 2024, this court issued an abstract of judgment in this case under Part 4 of the form. The court indicated that there were, quote unquote, no mental health concerns with the defendant. Number 2, yet at trial, evidence was permitted that defendant had significant mental health concerns throughout the case. Dr. Walla, Dr. Martin, and Dr. Westcott all testified about defendant's mental health issues. Video evidence revealed behavior by defendant while awaiting trial that raised concerns about his mental health as well. Number 3, providing accurate information on the abstract of judgment is critical to ensure the DOC is aware of the defendant's mental health issues, so the defendant will receive continued care and appropriate placement, as well as effective treatment and medicine, etc. There you go. Now, this is where we get to the holy shit defendant Richard Allen verified motion to correct errors. Again, comes now defendant Richard Allen by and through his counsel and files his verified motion to correct errors. For the reasons that follow, the court should either vacate Mr. Allen's convictions and or set the matter or matters set out below for a hearing. Okay. And yes, Tommy, the Constitution matters. I mean, I think that should go without saying, right, Tommy? But for whatever reason, people in Idaho and Indiana, they just don't seem to get it. So anybody that can truly argue with this piece of paper or these 24 pages that I'm about to read, like, there's no argument. Like, there is no argument. Like, I am patiently awaiting the state's response to this. Like, just keep digging that hole, baby. But here we go. This is number one. Number one. Wake up, people. Take a sip. This is what they're drinking in Indiana. Cough syrup. Daily. So, in violation of the 6th and 14th Amendments, Mr. Allen was deprived of counsel at the safekeeping proceeding on November 3rd, 2022. That proceeding was a critical stage at which Mr. Allen was entitled to be represented by counsel, and then states a case law. Now, I can totally tell that somebody, in my personal opinion, and maybe this is our first ever seeing Jennifer write and help in writing of motions, but I can tell somebody else is here writing. I don't know if you guys could tell that, but I could tell. And maybe I'm wrong, but I sense a different flow here, and I like it. Anyways. So it's a 1984 case, United States versus Chronic. You got that, Chronic? The court must presume Mr. Allen was prejudiced by being unrepresented during that proceeding. Can you believe it? Indiana Code governs safekeeping proceedings for pretrial detainees and provides in full the following. So again, the defense is saying Mr. Allen was not represented at the safekeeping hearing. Okay? And we should all be saying, oh, excuse me, they had a hearing and Richard Allen didn't have an attorney there? Wait, what? So there's no debating this. Mr. Allen was there without an attorney. This is fact. Okay? So there's nothing you can say to combat this. This is a fact. Okay. Now, 35-33-11-1. Transfers for personal safety or safety of others. So upon motion by the sheriff, 1, 2 is the prosecuting attorney, 3, the defendant or his counsel, 4, the attorney general, or 5, the court, alleging that an inmate in a county jail awaiting trial is in danger of serious bodily harm. So you can continue on to read, like, what is this whole safekeeping and why is it, why do they have it? What is it? And here's where it says, upon motion by either the sheriff, the prosecuting attorney, a defendant or his counsel, or the attorney general or the court. So you have to put a motion in, and then you have to allege that an inmate in a county jail awaiting trial is in danger of serious bodily injury or death, or represents a substantial threat to the safety of others. The court shall determine whether the inmate is in imminent danger or serious bodily injury or death, or they have to then prove all that. Okay? So, Indiana Code also governs safekeeping proceedings for pretrial detainees and provides in full. Post-transfer hearing, right of inmate to refuse transfer. So the inmate or receiving authority is entitled to a post-transfer hearing upon request. The inmate may refuse a transfer if the only issue is his personal safety. So if Richard Allen wants to say, hey, if the only reason we're moving me is because this is to protect me because people are going to come after me, okay, I don't want it. And guess what? There ain't a damn thing anybody can do about it. You're going to have to prove that that's for all these other reasons. And when I say prove, like, yeah, this hearing where Richard Allen was not represented by an attorney. So here we go. These are the facts. What is up, Ange? Mr. Allen was interrogated and arrested on October 26, 2022, and booked into the Carroll County Jail under an alias. It's like it was like Justin Timberlake checking in to the Ritz under a fake name, okay? So that like the mobs of girls don't come after him and blah, blah, blah. So Richard Allen was booked under an alias. The next day, October 27, 2022, Kathy Allen, you know, Mr. Allen's wife, well, she hired an attorney named Brett Gibson to represent Mr. Allen. And that's here attached as Exhibit 1, which is the affidavit of Kathy Allen. In the evening of October 27th, Mr. Gibson sent a letter by email to the Carroll County Sheriff's Office and to none other than Nicholas McLeland, the Carroll County Prosecutor. Again, Exhibit 1B. What emerges from Defendant's Exhibit 1C and 1D is the following. Sheriff Lazenby, let's be honest, confirmed receipt of Mr. Gibson's letter by telephone the evening of the October 17th. Also on October 17th, however, over the phone, someone at the Carroll County Jail told Mr. Gibson that Mr. Allen was not an inmate. Why? Because we don't have a Mr. Allen here. Who the hell is Mr. Allen? We don't have a Mr. Allen here because remember, Mr. Allen was checked in under a fake name. Okay? This is wild. I love it. I love wild shit. Cheers, drinking the syrup all day, every day. So, Mr. Gibson then contacted Mr. McLeland by email, after which Mr. McLeland called Mr. Gibson on his cell phone. Mr. McLeland told Mr. Gibson that Mr. Allen was listed at the jail under a different name, an alias, but arranged for Mr. Gibson to meet with Mr. Allen. Mr. Gibson went to the Carroll County Jail where someone from the sheriff's office took Mr. Gibson to a meeting room. It appeared to Mr. Gibson that the regular jail staff did not know Mr. Allen was there. Still, on the evening of October 27th, Mr. Gibson met with Mr. Allen and advised him not to discuss his case over the telephone because calls would certainly be recorded. At about 10 p.m. on October 27th, 2022, Mr. Gibson called none other than Mrs. Allen to say he would not be able to get Mr. Allen out of jail because he was going to be charged with 2 counts of murder the next day. Please see Exhibit 1. On October 28, 2022, then the next day, without Mr. Gibson present, even though Mr. McLeland and Sheriff Lazenby both knew Mr. Allen was represented by Mr. Gibson, Mr. Allen was charged with 2 counts of murder, and Judge Diener held Mr. Allen's initial hearing. Shortly after his initial hearing on October 28th, Mr. Allen was whisked away from the Carroll County Jail to the White County Jail without a safekeeping order authorizing the transfer. On November 1st, 2022, a letter from Mr. Allen was mailed from the White County Jail to the Carroll Circuit Court. The letter and the envelope are part of the record in this case. In that letter, Mr. Allen requested that the court appoint counsel for him. Nothing in the letter indicated he was not already represented. For some reason, although it had sufficient postage and was correctly addressed to the Carroll Circuit Court, Mr. Allen's letter requesting the appointment of counsel was returned to the White County Jail. It was then remailed from there and is shown filed in this court on November 9th, 2022. That was an error. Why is that an error? Well, we're about to tell you why. Under the mailbox rule, as a matter of law, Mr. Allen's letter was considered filed with the court as of November 1st, 2022, the day his letter was mailed from the White County Jail. In quotes, the prison mailbox rule, recognized by the United States Supreme Court in Houston versus Lack as a 1998 case, provides that pro se filings from an incarcerated litigant are considered filed at the same time that they are delivered to prison authorities for forwarding to the court. See all this, court or case law and where it's at. That's how I can tell that it's somebody that's writing differently than Baldwin. Baldwin doesn't do that. The safekeeping proceeding was plainly illegal from start to finish. Boom. Like, there is no arguing this. You can't argue this. You can't argue this. First, Sheriff Lisenby transferred Mr. Allen to the White County Jail on October 28, 2022, with no safekeeping order in place. What the fuck? Next, Sheriff Lisenby had no standing to make the safekeeping request on November 3rd, 2022, due to the fact that Mr. Allen had been illegally transferred to the White County Jail on October 28, 2022. Once Mr. Allen was in the White County Jail, the White County Sheriff was, quote unquote, the sheriff statutorily authorized to make a safekeeping request under Indiana code. Because Sheriff Lisenby had no standing to make the safekeeping request, this is where it gets so amazing. Judge Diener then had no motherfucking jurisdiction. None. No jurisdiction to consider it. Because Judge Diener had no jurisdiction to issue it, the safekeeping order was literally void. Void. A judgment is void if it grants rights or reliefs to a party that does not have standing to pursue the action. That is what void means. Second, Mr. Allen had the right to have a judge other than Judge Diener decide whether to issue a safekeeping order at Lisenby's request. That is because Judge Diener had engaged in ex parte communications with Sheriff Lisenby. You guys remember back in the beginning, they made some big to-do about this Judge Diener coming out and saying, I'm only person running this court. I have no help. Oh my, he was a little crybaby bitch about it. Remember all that? Send help. Please send help. SOS, baby. You guys remember all that? Smoke and mirrors. I remember like it was yesterday. I was like, wow, this is very strange behavior for a judge acting like he's a big old platypus, He says a platypus, Ready? So now we're going to hear the real story behind it, of why Judge Diener was crying and acting like I have no help. I'm running this by myself. I don't even know what we're doing over here. All that bullshit. So this is a real story. So the crying that, Judge Diener put in in a filing when he, recused himself. Yeah, that's not the real story. Here is the real story. So here it is. Mr. Allen had the right to have a judge other than Judge Diener decide whether to issue a safekeeping order as at Lisenby's request. That is because Judge Diener had engaged in ex parte communications with Sheriff Lisenby, helping Sheriff Lisenby draft his safekeeping request in violation of Rule 3.10 of the Code of Judicial Conduct. Yeah, the code. Rule 3.10 prohibits judges from drafting or reviewing documents except for family members. Jeez. Judge Diener also violated Rule 2.9 of the code by engaging in substantive ex parte communications with Lesenby, which helping Lesenby draft the safekeeping order certainly were. Having violated both Rule 310 and 2.9, Judge Diener was obligated then under Rule 2.11 of the code to recuse himself and request appointment of a special judge before he issued the safekeeping order, not after, which is what he did on November 3rd. Boom, daddy. So again, his whole cry, oh, I'm the only person here working. I don't even have any staff. You know, all that stuff. Yeah, no, that's not, that didn't happen. This is the real shit here. And big part is that, yeah, no, you would have done that before this date, the day that you issued that safekeeping order. So all of this, bye-bye. Like, I mean, this is so, like, when you want to talk about like correcting something, like, there is no like if this is going to happen. Okay. It's when this is changing. Richard Allen is going to have another trial. Okay. That will happen. This is never gonna stand and uphold any, I mean, this is first grade work in a 12th grade classroom. Okay. First grade work in a 12th grade classroom with a bunch of first graders cheating on 12th grade work. Okay. Okay. Exactly, Murky. Remember all that? Diener claiming he was afraid for his life and family kind of makes sense now. Him knowing he did all of this. Little fucking liar. All of them are liars. So, okay. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. So the third thing then. Sheriff Lesenby's November 3rd, 2022 request by the sheriff of Carroll County, Indiana, to transfer inmate from the custody of the sheriff to the custody of the Indiana Department of Corrections for safekeeping, in quotes, was not served on anyone. It was not served upon anyone. There is no certificate of service attached. Indiana Code 3533.11.1 requires a safekeeping request to be made by motion. Indiana Trial Rules 5A2 and 3 require that Sheriff Lesenby's motion for safekeeping order be served on the parties. Because Sheriff Lesenby knew that Mr. Gibson was representing Mr. Allen, he was required to serve Mr. Gibson with his motion for a safekeeping order. Even if he claims Mr. Gibson was not representing Mr. Allen at the same time, then Sheriff Lesenby was required to then serve none other than Mr. motherfucking Allen. Hello. Fourth, Sheriff Lesenby's safekeeping request was not verified. There was therefore literally no evidence before Judge Diener from which he could make any factual findings required by Indiana Code 3533.11.1 that would authorize a safekeeping order. It's like going and getting a protective order, you guys, okay? A protective order. Just because you have a date and a hearing set, let's say that the motherfucking person that you have a protective order against, at least in the state of Ohio, a civil protective order, if they don't show up to it, you just don't automatically get your protection order. Just so you guys know that. You still have to present your case and you still have to meet your burden. Whether or not that person that you are seeking out a protection order against shows up, even after they were properly served. Now, if you never provide service upon that person, then there is no motherfucking hearing ever. Because proper service is required to then have a hearing. I mean, it's just 101. So, Fifth, because a factual finding was required to authorize a safekeeping order, a hearing with notice to the parties on Sheriff Lesenby's safekeeping request was required. Sixth, and perhaps most importantly, Mr. Allen had an absolute right to refuse being transferred to the custody of the department. Sheriff Lesenby's safekeeping request alleged no statutorily authorized basis for a safekeeping order other than a concern for, quote unquote, Mr. Allen's personal safety. End quote. If the reason for a safekeeping transfer is only a defendant's personal safety, a defendant may refuse the transfer. And who the hell wouldn't? I'm not going to fucking Max. Get the fuck out of here. Yep, I'm good right here. Thanks. Mr. Allen had no opportunity to exercise his right to refuse the transfer to the Indiana Department of Corrections custody or to make any of the objections set out above to the entire course of the proceeding. That is for a quite simple reason. Mr. Allen, either personally or through his lawyer, Mr. Gibson, had no notice of the legal skullduggery that would land him in solitary confinement at the Westville Control Unit and then at Wabash Valley Correctional Facility and Case County Jail for 23 months pending trial. Because Mr. Allen had no notice of what was afoot, neither he nor his lawyer could make any of the arguments that would have necessarily prevented Mr. Allen's transfer. Finally, Mr. Allen's own absence from the safekeeping proceeding should be treated no differently from the absence of a lawyer to represent him. Indiana courts hold pro se litigants to the same standard trained lawyers. You guys know that's amazing right there. So Richard Allen wasn't at his own safekeeping hearing, nor was he represented. Dude, this is just absolute. I mean, this is fact here. This is absolute wild. How in the world did this ever get to this point? Finally, Mr. Allen's own, I already just said that, sorry. One consequence of this should be that the Sixth Amendment and Article 113A of the Indiana Constitution should apply when a pro se litigant is excluded from a proceeding at which he or she has the right to be present and participate in. It is a violation of the Sixth Amendment to completely deprive a defendant of counsel at any critical stage of a criminal prosecution. You guys get freaking attorneys on like the DUI bullshit when you get pulled over. You know, do you want to talk to an attorney? Okay, because that's criminal. I mean, this is a double homicide. I mean, this is absolutely disgusting. This is fucking crazy. Wow. The safekeeping proceeding, such as it was a critical stage at which Mr. Allen had a Sixth Amendment right to have his lawyer interpose all the objections to the November 3rd safekeeping order set out above. A critical stage is one holding, quote unquote, significant consequences for the accused, end quote. Because Mr. Allen was entirely and unconstitutionally deprived of counsel at the safekeeping, quote unquote, proceeding, the court must presume Mr. Allen was prejudiced, the best word in all of law. Prejudiced by that deprivation of counsel. Alternatively, Article 113A of the Indiana Constitution provides in part, in all criminal prosecutions, the accused shall have the right to be heard by himself and counsel. Again, Section 13A affords citizens ever greater protection than its federal counterpart. Not only does 13A guarantee a criminal defendant the right to counsel at any critical stage of the prosecution, but, in quotes, The rights afforded under Section 13 also attach prior to the filings of formal charges against the defendant, end quote. There is a footer up here, and the court need not speculate whether safekeeping proceedings have serious consequences for an accused. In addition to being moved hours away from his lawyers for over 23 months, Mr. Allen was unconstitutionally kept in solitary confinement in an Indiana Department of Corrections prison and was shackled, leashed, and hooked and deprived of human contact. Again, violation of due process for pretrial detainees to be kept in conditions amounting to punishment. As a consequence of that torture, Mr. Allen became psychotic. Short of his death, it is hard to imagine more serious consequences for Mr. Allen flowing from the November 3rd safekeeping quote-unquote proceeding. Mr. Allen. Oopsies. Mr. Allen was not afforded either the right to be heard by counsel or by himself at the safekeeping quote-unquote proceeding. This should be particularly disturbing because had he been given the opportunity to do so, Mr. Allen had an absolute personal right to refuse the transfer to the department's custody. In either case, accordingly, the court should vacate Mr. Allen's convictions or set this motion for a hearing. Now, just when you thought it couldn't get any worse, let's go into number one. In violation of the due process clause of the 14th Amendment, the state presented the testimony of Brad Weber that Mr. Weber arrived home in his white van about 2:30 p.m. on February 13th, 2017, either knowing that testimony was false before it was elicited or failing to correct it once it had been elicited. So this, to me, in my opinion, is when you want to talk about which one, Lana, do you think that's going to be like, okay, you know, there's four things we're going to talk about here. Which one holds the most? This one holds the most. This one holds the most. Thank you so much there. Tippy Hadron Collider, is that right? Thanks for all of your hard work and dedication, Lana. Well, thank you. Now you're saying, oh, you're probably saying to yourselves, okay, wait, what is this, Lana? You went after Brad Weber. And I said, yeah, Brad, why'd you do it? Why'd you lie on the stand? Okay, it wasn't like, why'd you do it? Why'd you kill the girls? All right, when he came out with his flannel shirt, hiking it over to the bar, okay, mofo couldn't get out of there fast enough. Okay, I went JLR on his ass, and I said, Brad Weber, why'd you do it, Brad? Okay, broke my foot up in his ass. And like I said, this is why. So I need to get that that meme, by the way, from Ange over there, so I could play it at a time like this. It was great. I was there. Donnie, thank you. I loved it, right? Well, because I was there and I knew what the hell had happened. Like, I was like, wait, this month, like, I was like, wait, he changed up his testimony from what he did in his deposition. And it's like, okay, this will get corrected though, because, you know, the state or the defense hasn't gone yet. This is, you know, the prosecution calling him as a prosecution witness. So, so his ass, he testified during the second part of that day. And so here I was waiting for good old Mr. Brad to come on out of that motherfucker. And he comes and he is in his flannel. He looks like a disheveled mess. And he is hightailing it over there to, what was the name of that bar? The Office? The Office. Okay. And yeah, I went all JLR on his ass. All right. So everybody that was so upset about JLR doing that to Richard Allen, okay, well, I did it to Brad Weber. Okay. So it's all even in this mofo. Okay. Yeah. He was high stepping it. He like literally was, you would have thought the man robbed something, and it was like, oh my God, I gotta get out of here. So here we go. A conviction obtained through use of false evidence known to be such by representatives of the state must fall under the 14th Amendment. The same result obtains when the state, although not soliciting false evidence, allows it to go uncorrected when it appears. Okay. And so again, we have a couple different cases cited there. All well-known cases. Okay, so at trial, the undisputed evidence at trial between the two sides was that Liberty German's cellular telephone stopped moving at 2:18 p.m. on February 13th, 2017 for 7 minutes until 2:25 p.m. It then started moving again and stopped moving permanently at 2:32 p.m. This is undisputed. That's what I mean. Both sides, presenting this and claiming this at trial. That's what undisputed means. When both sides, like there's nothing in dispute here. That sentence, undisputed. In closing argument. Now think about what that juror said. Okay. About how impactful that closing argument by Nick McLeland was. So again, in closing argument, Mr. McLeland called it a hard fact that Liberty German's phone stopped moving at 2:32 p.m. Okay, a hard fact. The state introduced an alleged confession by Mr. Allen to Dr. Monica Walla, a psychologist contracted by the Indiana Department of Corrections to treat inmates at Westville Correctional Facility. In this alleged confession, Dr. Walla, again, remember, her notes were destroyed. There's no evidence of this. But Dr. Walla stated that Mr. Allen said that he had abducted LG and AW on the south side of the Monon High Bridge. Okay. And forced them down the hill to the south side of Deer Creek. Dr. Walla said, Mr. Allen said he was on the south side of Deer Creek and was planning on sexually assaulting LG and AW when he was interrupted by a van. Now insert gray hues in his pubes and everything that was going on at his channel, where Monica Walla was like, woo, yeah, I watch all these channels. Gray hues is just so good and blah, blah, blah. And yeah, whippy hoo, woo, yay, yay, gray. Okay. So now Mr. Allen said he became scared when he saw the van and crossed Deer Creek from south to north, from the Weber property to Ron Logan's property, taking LG and AEW with his ass. Come on, girls. Let's chop through this water. Now, the state also introduced the testimony of Brad Weber that he left work at the Subaru factory in Lafayette, Indiana. I would die if they put Brad Weber in a Subaru commercial, man. Can you imagine Brad Weber in a Subaru commercial?
100% in his flannel?
In his flannel, man?
100%.
Fuck yeah, they need to give him something.
A Subaru?
They need to give him a damn commercial spot.
Give him a Subaru.
At the Super Bowl.
God damn it.
Okay, I'm going to put it in. All right. So the state also introduced the testimony of Brad Weber that he left work at the Subaru factory in Lafayette, Indiana at 2:02 p.m. on February 13th, 2017, and arrived home in his white cargo van at about 2:30 p.m. This is what he said, at about 2:30 p.m., in quotes. From Mr. Weber's testimony, the state then argued Mr. Weber's arrival home in his van was what interrupted Mr. Allen, causing him to take LG and AW across Deer Creek to kill them on Ron Logan's property. The arrival of Mr. Weber's van at about 2:30 was, quote unquote, a detail only the killer would know, said the state. You guys, now go back and visualize Murder, She Wrote doing their juror interview. And what did she say? Oh, yeah, only the killer would know, and how much stock they put into the van. But what did they do when they initially left and broke, and here the case is in your hands? The first thing that those jurors went and did is they went and made a timeline. And Nick McClellan knew that they would go and make a timeline, because as any veteran good prosecutor would know, the juries are going to make a timeline. And so he needed to seal up his timeline. But the problem is, the state also contended that LG and AW died in time to 2:32 p.m. when the Apple Health data from LG's phone showed that the phone stopped moving. If the arrival of Mr. Brad Weber in his van is what in fact interrupted Mr. Allen, forcing him across Deer Creek, Mr. Weber would have had to arrive near his parents' house at the end of the private drive before 2:32. This is a fact, right? Because that's what, oh my God, he saw this van and was like, oh God, girls, come on, we're running through, the water, and we gotta, oh my God, like we gotta get to the other side. I mean, I'm shook in here, and I gotta take you guys, and we can't do this right here, right? And so if that phone never moves again after 2:32, those steps and the phone moving has to happen before 2:32. You understand why they're putting this in here, okay? Awesome. Now, in fact, Mr. Weber could not have arrived anywhere on the private drive before. Wait, where was I at? I slipped it. Okay. Okay. When, according to the state, the phone stopped moving and was located on the north side of Deer Creek. This is again by the state. This is a hard fact. 2:32. That phone never moves again. 2:32. Nick McClellan. So they have to be on the other side where they died before 2:32. In fact, Mr. Weber could not have arrived anywhere on the private drive before 2:44 and 54 p.m. on February 13, 2017, because his arrival at about 2:30 could not have been a detail only the killer would know, because it did not happen. And everybody's probably saying, like, wait, what do you mean it did not happen? What do you mean it did not happen? The state knew or should have known as much. So basically, if Brad Weber is driving back at 2:44 and 54 seconds, all right, if he's driving back at 2:44 and 54 seconds, Richard Allen could have never seen him do that, because he's already on the other side of the river with the phone with the girls. Understand? Because I got to break this down for the jury, because we know they listening. So when they would have made that timeline in the jury room, okay, they didn't have what we're about to tell you guys. They didn't have this. All right. So the state knew or should have known as much, and the state either elicited Mr. Weber's testimony about the time he arrived home, knowing it was false ahead of time, or failed to correct the testimony once it had been elicited. Defendant's Exhibit 3A, as attested to by Matthew Hoffman in Defendant's Exhibit 3, it is a video recording made on February 13, 2017 by a security camera that was in the house at 5998 West County Road 252 North. The video recording was provided to the defense by the state and has therefore been in the state's possession. Ready? Wait, Lana, you're telling me that they have video evidence of Brad Weber's van coming home? That's exactly what I'm saying. Okay? That's exactly what I'm saying. And are you saying that the video depicts Brad Weber's van at 2:44 and 54 seconds? That's exactly what I'm saying. That's exactly what I'm saying. Wait a second. And the state knew this and allowed Brad Weber to testify on the stand that he came home about 2:30.
Under oath.
Okay. Knowing that Brad Weber, in fact, came home at 2:44. Yeah, that's what I'm saying. Well, okay, you got more from me, right? Sure do. The security camera faced west, northwest, and appears to have recorded continuously. Again, that's in the affidavit. Based on the date and timestamps on the video, it appears that the security camera was set to record date and time information as part of the recording. The time on the security camera was set 12 hours behind, such that 12 a.m. is really 12 p.m. on the same day. This is apparent due to the daylight and moonlight on the video and the associated timestamps. The security camera had a wide-angle lens that captured video of traffic on West 252 North and County Road North 625 West. And the beginning of the private drive to the Weber property, which begins as a continuation of N60 625 West, approximately 190 feet north of that road, is intersection with West 252 North. County roads, So basically, we're able to see which and when a vehicle would enter the Weber property. I didn't even believe this, right? And so I can't even believe it, but there's a video online of it. And so all you have to do is click this link, okay? So according to the time and date stamps on the security camera recording, Exhibit 3A shows a white vehicle going north on this street, entering the frame at approximately 2:44 and 33 seconds on February 13, 2017. Exhibit 3A also shows a white vehicle continuing into the private drive to the Weber property at approximately 2:44 and 54 seconds. It is viewable on YouTube at the following address. Do you guys want to see it? Do you guys want to see the video? I can show you guys the video if you guys want to see the video. We'll show you guys the video here in a second. Exhibit 3B is a video file that contains 3 zoomed clips from the video recording that is Exhibit 3A. Each successful clip in Exhibit 3B is zoomed to a greater magnification. Exhibit 3. In all 3 zoom clips of Exhibit 3B, a white cargo van can be seen going north just after 2:44 and 33 seconds on February 13, 2017. Exhibit 3B is viewable on this YouTube at the following address. So it's all there. The state knew it, baby. The state knew it. Exhibit 3C is a PDF with still photographs taken from the Exhibit 3B at each magnification level. Exhibit 3, for each magnification level, zoom level 1, 2, and 3. There are 3 stills showing the white cargo van. 1 just before it passes the white sunlit house in the background on the west side of North 625 West. Number 2, as it blocks the sunlit house. And number 3, just after it has passed the sunlit house. Reproduced below is the first still photograph on page 3 of Exhibit 3C. Okay. Exhibit 3D is a photograph of Brad Weber's white cargo van provided to the defense by the state and therefore has been in the state's possession. The photograph of Mr. Weber's white cargo van in Exhibit 3D appears to be at least similar to the white cargo van as it appears in Exhibit 3B and 3C. The zoomed photo clips and zoomed still photographs created from Exhibit 3A, the original security camera recording. So this is just to show you guys that this is his van. Now, other video files produced by the security camera. This is to me is what the most compelling part is right here, is when we talk about this. And so other video files produced by the security camera in the state's possession, provided to the defense in discovery, and covering the time of 2 p.m. to 4 p.m. on February 13, 2017, which is like, that's all they gave them. That's all they cared about was 2 to 4. Like, wow. They do not show any other van driving north on a North 625 West into the private drive to the Weber property or traveling east on the West 252 North during that time. Meaning that, remember how he testified, right? And he said, I came home at approximately 2:30. I was about 2:30, right? So between 2 and 4 p.m., there is no other vehicles. None. This is the only one. Exhibit 3A, 3B, and 3C reflect that if Mr. Weber returned home in his cargo white van, he could only have arrived home some minutes after 2:44 and 54 seconds on February 13th, 2017, 12 minutes after the time the extraction of LG's cellular telephone shows the telephone stopped moving at 2:32. The defense could have never in a million thousand years, well, maybe they could have because they realized who they're playing with, that the prosecution in the middle of the trial would decide that we are going to railroad Richard Allen because their case was crumbling. Like we had all told you guys about the case crumbling. And it was up and until Weber testified is when mainstream media was like, Brad Weber just testified and it just totally killed the prosecution or the defense of Richard Allen. Yada, yada, yada. I mean, go listen to mainstream media literally jerk off to what they put out after Brad Weber testified. Up and until that point, the prosecution was getting plowed like a 1980s porn. Debbie does Delphi, man. It's true. Now, either the white cargo van shown in Exhibit 3A, 3B, and 3C is Mr. Weber's, with him arriving home some minutes after 2:44 and 54 seconds on February 13, 2017, or it is not. In either event, no white cargo van, or any other van for that matter, entered the private drive to the Weber property after 2 p.m. and at or before 2:32 p.m. on February 13th. The whole point of this, though, is, again, the time of the extraction of Libby German's cellular telephone shows the telephone stopped moving, in which everybody agreed, and they tried to say that, hey, 2:32. And I said, yeah, get the hell out of here. Go watch my live the one day when I was back in that property. I trespassed like a motherfucker. I got all my data. Y'all can get blown. Okay? I'm just kidding. I didn't need a trespass. I had somebody else do it for me. Those Delphi people will do anything for a buck. Now, give me more credit than that. Defendant's Exhibit 3E is a redacted FBI. Now, there's more to this. There's so much more to this. So here we go. Wow. So if it in fact, Richard Allen saw Brad and he got scared and wanted to cross the river then with the girls, okay, that would have all had to be well after 2:44 and some change. But remember, then that totally blows up the state's case because the girl's phone, it stops moving at 2:32 because not because it got into a vehicle and drove off, but because they were already on the other side of the river and they were, that phone was no longer moving because the girls were no longer moving. Because Abby had the wherewithal to hide it under a shoe. Remember? Okay. But here. Defendant's Exhibit 3E is a redacted FBI subject information sheet for Bradley Weber and is dated March 3rd, 2017. The FBI interviewed him. The unredacted version of Exhibit 3E was provided to the defense by the state and has therefore been in the state's possession. Exhibit 3E, the FBI subject information sheet for Mr. Weber, says, in quotes, on February 2/13/2017, Weber's phone pings to parent's address overlooking crime scene initially at 2:50 p.m. and repeatedly pings around the property until 11:55 p.m. End quote. That Mr. Weber's phone first pings to his parents' address at 2:50 p.m. on February 13, 2017 is consistent with the video evidence in Exhibits 3A, 3B, and 3C, showing that Mr. Weber could not have arrived home in his white cargo van until sometime after 2:44 and 54 seconds that day. Do you understand now why they wanted to be able to call that FBI personnel and then, oh, no, you need to have him here in person because McLeland objected to this FBI agent testifying via Zoom. How is that possible in the name of justice? Everything is supposed to be in the name of justice. That's why a judge, if you're late, let's say a day or two on a filing, but it's in the name of justice that and truth, and that this is a very, important document and it has all this shit in it. Nope, you're late a day or two. In the name of justice, you're gonna accept that. Okay. So they, meaning the defense, this is really important for the juror to listen to. The juror said that it seemed like the defense was just so unorganized. Well, I'm going to explain something to you, sweet shug. The defense wasn't unorganized. At every chance and at every turn, the defense was getting blackballed, hosed, whatever word you want to use. Hey, the only way that we can, rebut what the hell that man just decided to say on the stand was to bring in this FBI agent, which is the only way to get any of this in. Okay? And the judge would not allow this FBI agent to testify via Zoom. And because the FBI agent was in Texas, doing stuff for the election, running detail for the election. Now, if you don't think that Brad Weber and Nick McLeland and that fat fuck Jerry Holman didn't sit down and talk before Mr. Weber's testimony the day that the state called him, then you're a fucking fool. Why would anybody in 1,000,000 years put themselves like Richard Allen did at the crime scene at the time of the crime being committed? Brad Weber went ahead and did that. Why? Think about that for a minute. Now, from both Exhibit 3A, the security camera video recording, and Exhibit 3F, the FBI subject information sheet for Mr. Weber, the state either knew that Mr. Weber's testimony about the time of his arrival home would be false before it was elicited, or failed to correct it once it had been elicited. So if you want to ask Brad Weber, hey, what time did you come home? and he says to you about 2:30, well, then guess what the prosecutor is supposed to do then? How does about 2:44 sound? Does that sound about right? Could it have been 2:45? Yeah, it could have been 2:45. You know what I mean? And I would love to see the transcripts, or maybe even if I go back and look at the way that we documented the line of questioning with even Andrea's stuff, to see, to say on cross-examination, if Brad Weber was asked, like, are you sure you were home at 2:30? Could it have been at 2:45? Could have been 3? Could have been 3:15? But the state knew that Brad Weber was not home at 2:30, like his testimony said. They knew that. And so people that are out there saying, well, who cares? Like, that's that guy's fault. Well, actually, no, it's not just that guy's fault. Because if you can prove that the state knew that it was false when he testified, just like I said, Vanessa Walsh did when her lawyer allowed her to testify falsely, and that fucking bitch knew. I just didn't want to deal with their asses anymore in Colorado. I could have her fucking bar license literally gone. And I said, why in the world would you want to lose your license over a pig like her? Anyways, so yeah, you can't let, like, that can't happen. And so the question is, did the state know? Well, the state was the one that handed over the discovery, and the state knew, based off of this FBI report, they knew that Brad Weber was not home at 2:30, and they knew that anybody that's making a timeline, okay, and saying that, that Richard Allen, that van that Richard Allen saw, that was Brad Weber, to allow the jury to think that, and it's exactly what they did, purposefully, because during the middle of the trial, McLeland decided, because he had no choice, or he was going to lose the case. He was going to lose his case. And he made a choice. Okay, that if he needed to, he was going to play his trump card, this puppy. And he played it. And now it's all going to come down. The house of cards. Remember what the jurors said. They put a timeline together. And they put on the timeline that Brad Weber came home at 2:30 with his van, and that is what shook up Richard Allen, and that they went across the bridge then, and then, killed the girls away over there because he got, startled and scared and took the girls across the bridge. And at 2:32, you guys, the phone stops moving. And it's because the state says that, because it was already on the other side and it was underneath the shoe. And because down the hill was at, 15 minutes before that, and blah, blah, blah. Okay. So now when the jury is going back to deliberate, they can't say that RA's confession, like they did, and him being the only person to know, only something the killer would know. Only the killer would know the white van was coming home at that time. That's a bunch of fucking bullshit. The white van was never seen by Richard Allen, and it didn't startle him that he went across the way, because then how do you explain the phone still moving, or the phone not moving after 2:32 if they would have been on the south side still? You understand? Now, this is so good. Thank you so much, Murder Sheet. Thank you so much, Murder Sheet. because that's what sealed the deal for those jurors. Those jurors 100% said that the van sealed it, that that's the thing, that's something only the killer would know. That's diabolical. You understand? Nick McClellan knows. He knew it when he was soliciting the answers out of Brad Weber. Okay? He knew what that jury was going to do with that information. And he knew that there was nothing that the defense could do to trump it. Because Judge Gall didn't allow them to stream via Zoom to testify in a murder trial. A man's life is on the line. 2 girls getting justice is on the line. And Nick McClellan pulls this shit and gets motherfucking caught, and I fucking love it. And Richard Allen, you hang on, man. You hang on. When the state introduces testimony it knows will be false or fails to correct testimony it knows or should know to be false once elicited, a conviction must be vacated or reversed if the false evidence may have had an effect on the outcome of the trial. And this is where I said, and I made a community post about it, and I said, now this juror has a chance to redeem herself. Okay? I've been a hard critic of hers, and I have no problem saying that, and I was, and I still am. But here's an opportunity for her to literally read this, see this, and if everything that you said in your interview was true, then you, my friend, juror number 2, juror number 19 overall, you have a civic duty to write up an affidavit and take it to Nicholas McClellan as well as your other jurors, because this most certainly 100% affected your fucking decision. Or you lied in your interview with Murder Sheet. And now Murder Sheet, you now have a civic duty because you did the interview and it was unedited at one point. You have a civic duty to turn over all of that material to both sides, the defense, the prosecutors, because what you are in possession of is prong 3. Here they are. Number 1, again, if you try to get false testimony and elicit it, or if it just comes out and it's wrong and you don't correct it, then a conviction must be vacated or reversed if that false evidence, and this is false evidence, may, even just the word may, if it may, the word is may have had an effect on the outcome of the trial. And we have proof based off of that interview that it did. There's no may. It did. And so here's a chance for this girl, literally, to come out and be a freaking hero. You want to talk about being a hero? This girl, this juror, has a chance to be literally a hero.
Can I do a PSA for her really quick? I need to do a PSA for her really freaking quick. She says that the thing that swayed her is listening, and it was Nick McClellan's rebuttal, not his closing. And what he said was they try to solve their own crime. Okay, I'm sorry, juror, but you failed. You failed her. You didn't help her solve her own crime. You ignored the clues she put in place to get the person who actually did this behind bars. So do what's right when you see this, because all this is just, there's evidence here. This isn't something you can shake away. This is real stuff. So you need to do what's right. You need to come forward, and you need to admit that the things that you saw during that trial were smoke and mirrors.
No,
And
that you believed it because you said you trusted the prosecutor, and the prosecutor then delivered you this evidence, and you had no reason not to believe him that he would ever bring in a guy like he did in Brad Weber and get him to testify a certain way, okay,
Sure.
to then use us in a deliberating room to build a timeline and use Brad Weber and this van, which then you connect to one of Richard Allen's allegedly false confessions. Okay. And you're putting a little fucking bow on a pile of shit for us. And we bought it because we trusted you and we believed you. And that's exactly what you said in your interview.
Mm-hmm.
And
He
so
was so
I can't
trustworthy.
fault you for that. You're believing and trusting in a man, right? Who earned your trust, right?
But look at this now.
Yeah. And let me tell you something. He's a veteran prosecutor. He earned your trust, right? He knew that he needed to earn your trust. And then he waited until he did. And when you want to ask what the order was to call people to the stand, Brad Weber was a fucking Hail Goddamn Mary, but a fixed one. You think Mick Leland wanted to do this? You think he set out to do this? Then you crazy.
She asked a question. She said, if not Richard Allen, then who? That wasn't your job to say, if not Richard Allen, then who?
And
your job was to say, did Richard Allen do it? That was your one and only job. And you need to do what is right for Libby and for Abby.
You said, who else could it be on the bridge? You said, if the bridge guy is the killer, right? Well, guess what? Introduce Ron Logan, who literally lives right there. The kids were on his property. Ron Logan looks exactly like Bridge Guy, walks like him too, right? Oh, wait, Ron Logan wasn't allowed to be introduced. So when you want to say Bridge Guy equals the killer, okay. And who else could have been there? Well, how about the guy that the girls are on the property, and when you see him walking and, oh, wow, yeah, he looks like Bridge Guy too.
Read them the next stuff so they get it.
So right here, these are your 3 prongs. Number 1, that there was false testimony. Well, that's a check. There was false testimony. Number 2, that the government knew or should have known. And guess what? Yep. So number 2, check, check. And now 3, and this is the most important one in my opinion, that there is a likelihood that that false testimony affected the judgment of the jury. And that's the prong 3 right there. And only the juror or jurors can answer that for themselves. And I firmly, wholeheartedly know that number 6 is going to come out and say, fuck all you motherfuckers. I was crying in there. I had my glasses off. My fucking eyes were watering out of my head. I was a disheveled mess listening to you fucking assholes. And that fucking guy, I told you, that slick big pony motherfucker, he was not trustworthy. Look at this. I'm coming forward. Number 6, don't fail me now. He's a firecracker. Now, to obtain Mr. Allen's convictions, the state explicitly relied on Mr. Weber's testimony about the time he arrived home and used that testimony to then corroborate Dr. Walla's rendition of Mr. Allen's testimony that he became scared after he saw a van, so he took the girls to the north side of the Deer Creek and killed them. This was the only statement allegedly made by Mr. Allen that contained any detail of what the murders that might be true, because that footer says Mr. Allen also said that he shot the girls in the back and buried them in a shallow grave. Neither of the girls were shot in the back, and neither were buried in a shallow grave. The state therefore cannot show Mr. Weber's uncorrected false testimony about the time he arrived home did not have, quote unquote, an effect on the outcome of the trial. They cannot show that it did because guess what? This juror came out and 100% said that it did. 100% said that it did. And there's no going back from that. So murder sheet, once again, y'all are in this shit thicker than fucking shit. And I love it. I love it. I believe that juror, I think she might do the right thing. Why? Why do I think that? Because she just got blasted. That's why. And she'll look like a huge hypocrite if she doesn't. Right? Again, I can't thank Murder Sheet enough for doing that interview. Thank you so much. Alternatively, were the court to find that the state did not know or should not necessarily have known about Exhibit 3A, the security camera footage, the video, and Exhibit 3E, the FBI subject information sheet for Mr. Weber, then both exhibits constitute newly discovered evidence that would probably produce a different result at a new trial. So if you didn't know about these sheets, we didn't know those existed. Okay, then that's new evidence. Boy. What do you guys think? Now, number 2. You guys are like, God, wow. So, Lana, you think that's the most compelling? Absolutely, I do. You want to know why? Because it meets all 3. Period. The state knew about it. The state objected to having the FBI guy Zoom because if he would have stipulated to it, it would have happened. He knew that he couldn't stipulate to it because it was going to blow up the lie. Okay? So that's how you're going to show that they knew. And then how do you not know your own discovery that you turn over to the defense? Oh, because there was just so much discovery. We didn't even look at that video. You didn't look at that video? That video should have been what you were showing the freaking jury like you showed everything else to the jury, right? Now, number 2, Ron Logan's confession to Ricky Davis. Holy shit, we have a Ron Logan confession. When that trial number 2 happens, you're going to hear it here first. I'll make this really clear. There is no more Odinism. There is no more of that. You're going to take that and you're going to crumple it all up and you're going to throw it in the garbage. I don't want to hear one more fucking thing about Odinism because you know why? Because you're going to do what's best for your client, which is all right in here. You heard from the jury, which is a gift. Bridge guy. Who does Bridge guy look like? Bridge guy looks like none other than Ron Logan. Ron Logan is where the girls, he lied about him taking a vehicle that day. He lied about his alibi. He made a family member lie. The girls were found on his property, and you 100% are going to say that was Ron motherfucking Logan on that motherfucking bridge. Are we understanding each other? And you're going to take this timeline and you're going to shove it down the throats of these motherfucking jurors. And that man's going to come home because he is not the killer. Now, I'll continue. Ron Logan's confession to Ricky Davis before May 15, 2017 is newly discovered evidence entitling Mr. Allen to a new trial. Bella, how do you say it? Is it Dr. Core? Is it Michael Kors?
Can I say core, not cores?
Okay.
Core.
Is it? Yeah. Dr. Core was the forensic pathologist who conducted the autopsies of LG and AW. His original opinion, held for years, about how LG and AW died was that 2 weapons were used. You know, I was there. Yes. 2 weapons were used. Okay. He held that opinion for years. 2 weapons were used. One a straight blade and the other was a straight edge blade. For the first time at trial, having a eureka moment at his tool bench, Dr. Core opined that the girls could have been killed by a single box cutter rather than 2 different knives. Defendant's Exhibit 4A, as attested to by Matthew Hoffman in Defendant's Exhibit 4, is a redacted copy of a tip from the Orion database of tips dated May 15, 2017. That would just be a couple months after the girls were murdered. May 15, 2017. In that tip, which the state has always had, Ron Logan is alleged to have confessed to Ricky Davis sometime before May 15th, 2017, while they were in prison together, that he had killed LG and AW. The material part of Ron Logan's confession to Ricky Davis, as it appears in Exhibit 4A, is reproduced below. Logan confessed to Ricky step by step of killing the 2 girls. Logan told Ricky how he burned his clothes in a fire pit and where it was located, used box cutters, and struggled with one of the girls and thought drops of blood from his nose ended up on her clothes. Ricky also advised that he killed the older girl first. Ron Logan's confession to Ricky Davis, as reflected in the tip in the Orion database, and made a mere 3 months after the girls were killed, was detailed. Law enforcement, now remember, guys, there is a FBI agent out there. She's a female. There's an FBI agent out there who's a female. And she 100% was out there like, hey, Ron Logan is our guy. The crime scene was staged. Okay. Ron Logan's our guy. And they put together that probable cause affidavit and listed these things. And you would not be able to move her off of that. I believe that whenever that woman retires, she's going to write a book. And it's going to be about this case. If it doesn't come out in, trial 2. So she pegged it on Ron Logan day 1. So law enforcement followed up on the tip, Defendant's Exhibit 4B, as attested to by Matthew Hoffman in Exhibit 4, accurately reproduces the handwritten notes taken by Indiana State Police First Sergeant P. Hansard. This is an Indiana State Police officer. He is just going to take his notebook and he's going to go in and interview somebody, not recorded on a device. An Indiana State Police officer is about to do this. The interview was on June 21st, 2017. So the confession was on May 15th. Well, that's when the tip was put in. And they just get their asses on out there on June 21st, 2017. Like, what were you guys doing? I'm just curious. So they were at the Newcastle Correctional Facility regarding Ron Logan's confession to Ricky Davis. Now, those handwritten notes of First Sergeant are attached to the Indiana State Police Detective Nick Wolf's lead narrative summary cover sheet as it was provided to the defense in discovery. First Sergeant Hansard's notes of the interview with Ricky Davis about Ron Logan's confession provide even more detail. Here we go. This is insane. Hard as they are to decipher and subject to debate and correction, those notes reveal the following about Ron Logan's confession to Ricky Davis. Page 1 of Exhibit 4B is produced here. So what they did is, here's the page, and then, hey, this is how we interpret them. Feel free to change us. But it seems to say, talking about knowing one of their dads, to walk with them. One of them wanted to turn around, grabbed younger's shoulder. It's okay. Oldest freaked out. One said something about calling police. Sexual attack wasn't true. Originally not trying to go rape them. Paranoid about probation. felt like he crossed the line when he grabbed the youngest one. Okay, that's okay. The top half of page 2 of Exhibit 4B is reproduced below. The bottom half of the page duplicates the top half. It seems to say he started talking. Ironic, should have been in school. Knew one of their mom's waitress at a bar. Are you kidding me here?
The office.
That's what Abby's mom, she worked at a bar, you guys. Animals, walked with them, willing to go check out horses, and they couldn't make that word out. Okay. He told them he had rabbits in barn, walked through the trail in woods. Oldest paranoid, didn't want to go. Okay. Youngest wanted to go see the horses. The top half of page 3 of Exhibit 4B is reproduced below. There it is. Okay. It seems to say oldest turned to help youngest. Oldest started looking, kicking. Youngest seemed, he now grabs oldest. He said he got hit on the nose, scared he got blood on one of the girls, pulled box cutter out, slit oldest one, hit an artery. Box cutter, are you fucking kidding me? Hit an artery. This is everything that was testified to by the forensic pathologist. Youngest, scared, etc. Took little girl with him for a while, never said where. Now, remember the phone coming off and then on, and then why all those text messages started going? Remember all that crap? Remember Abby's hand? She was so clean. Okay, remember? No blood was on her. Redressed in the girl's other clothes. Okay. He said he cut her to cut both necks. So did he cut her after the fact? Did he kill her some different way? Remember Abby's, none of these girls had, their hands weren't tied. Abby didn't grab at her throat with her hands. And that's a normal reaction. That's what the one guy testified to. Cicero, he had never seen, if when there's a wound, your hands go to it to try to stop the bleeding. That's Libby's hands had blood all over them because of her neck, and it trying to stop the bleeding of her neck. Okay. And that she was squeezing so hard that there was, what is it when your eyes have what is it? Petechia. I think that's the word.
Yeah.
Yeah. And so there was a little bit of that. And they believe that was from, she caused that herself by squeezing her throat to stop the blood. And so there was blood all over Libby's hands. But Abby didn't have any blood on her hands. She was pristine. Okay.
Like this.
So anyways, ready for this part? He left again, came back later in the evening. Search was going on. Later on, late hours, tried to move oldest one to area not going to be found. Place where four-wheelers go. Burned his clothes in burn pile. They can't tell if it says hiking, hiking boots, gloves, bag. Top half of page 4. It seems to say soles of boots be in a burn pile. Next morning, you guys know this is what's crazy to me. Next morning, 2 other girls knocked on the door, asked to search the property. That's exactly what happened.
I see that word is unearthed in a burn pile.
He, feel weird if he said no. So he, said, sure, whatever. He let them take off, like, go ahead, do whatever. And then got a hold of family member and got out of area. Page 4, the bottom half. It seems to say, first time he'd seen them from property. Home, etc., guns, etc. During struggle, youngest girl not happened to friend to stand there, head, neck, artery. Defendant's Exhibit 4C is handwritten notes signed by Ricky Davis, dated June 21st, 2017, the same day First Sergeant Hanson interviewed him. The handwritten note is attached to the same lead narrative summary cover sheet and is contained in the same file as First Sergeant Hansard's handwritten notes that are Exhibit 4B and Exhibit 4. Ricky Davis's handwritten notes about Ron Logan's confession to him say, Mr. Logan has made references to the killings in Delphi, Indiana. He told me he was the one who had killed those girls, that it got out of hand. He walked with them in the woods to his property, and the girls wanted to turn back. Said something about he grabbed the youngest girl to reassure her it was okay. However, they panicked. This is exactly how I said it, that they walked on the same side, that they never crossed no river. Okay. And the way that we had gone that day is exactly what they did. Okay. So he had grabbed the youngest girl just to reassure, hey, it was okay. However, they panicked, and he also panicked. He indicated he ended up cutting the oldest with a box cutter. He went on telling me that he killed both of them because it took too far. Remember, he was on probation. And then those girls are going to, like, oh my God, say that I tried to do this. And then he freaked out. Like, think about all of that. And one thing just led to another thing. And it was like, oh my God, like, I guess I like a panic mess. And then, So in addition to the other details that fit the known facts, Ron Logan confessed to Ricky Davis that he used, quote unquote, box cutters. Now, I'm going to play devil's advocate here, right? Think about this. Let's say, for example, that just like Richard Allen, there was somebody that fed Ricky Davis all of this shit to say, okay? Because they were going to do the same thing, to like frame somebody. So if they were willing to do it about Richard Allen and, hey, get him, to say all these confessions and blah, 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 right? Feed him this shit. Whether you want to say that this is full of shit or whatever, if he was fed it, you guys, I don't care. Somebody or this man is saying these things, and these are the facts. The stuff that's in here is matching facts of this case that nobody knew except law enforcement or something that the killer would know, right? Thank you so much there, Brother Hector. Outstanding work you do, Lana. Shake it. Woo. I appreciate your and your team's time and dedication to the cases with the purpose of reaching the truth. Thank you so much. So I look at it like this. Either Ricky Davis was fed that information from law enforcement, which think about then what they thought happened, okay? And they're giving him details of the crime scene, okay? Details that only the killer would know, right? Fucking wild. Or Ron Logan's really the killer. Either way, it ain't Richard Allen. And the state knows all this stuff. And then they give the doctor, who never mentioned a single thing about a box cutter ever, he miraculously brings up about a box cutter at trial. And Bella is so pissed about that, by the way. Bella is so pissed about this box cutter. She is so pissed that a doctor would literally, I mean, how'd they get to you, Gramps? How'd they get to you? You just had a eureka moment to say box cutter. Ridiculous. So let's see, like I'm willing to give Ron Logan the benefit of the doubt on being railroaded the same way that they did to Richard Allen. And so like they were planning on just pinning it on, Ron Logan. But when you want to talk about somebody lying about an alibi, when you want to talk about somebody that said like I was, a family member picked me up and we went freaking going getting koi fish or whatever the hell he was talking about. No, he lied all day. He lied about going to the dumpster. He was on probation. He's a drunk. He can't drink. He can't drive. He wasn't supposed to be driving. So that's why he said he lied. He's like, oh, I didn't want to get in trouble for my, probation violation. Okay. So in addition to the other details that fit the known facts, Ron Logan confessed, like I said, box cutters to kill the girls. If instead of for the first time at Mr. Allen's trial, Dr. Kaur said 7 years earlier that, the girls could have been killed by box cutters, there would certainly have been probable cause to arrest and charge Ron Logan with the girls' murders. Think about it. If that doctor would have just said, oh God, this could be box cutters, then, oh my God, that's what that dude, it would have given credence to Ricky Davis. Like, oh my God, Ricky Davis told us that Ron Logan did this with box cutters, And so now, since the good doctor wants to bring that out here at a trial, wait a second. Ron Logan's the one that gave that confession to allegedly Ricky Davis. And that's what they're saying here. This is how they're saying it. It would have given, probable cause to charge Ron Logan with the girls' murders. As it was, the FBI 2 months before Ron Logan's confession to Ricky Davis had obtained a judicial finding of probable cause to search Ron Logan's property. That's what the FBI woman. Can you imagine if the FBI woman, did she know about this? Can you imagine tell me somebody out there can get this to her. I would love to know, maybe she's like, hey, that's it. I'm coming forward as well. Like, this is wild. Under the circumstances, Dr. Coe's testimony about a box cutter possibly being used to murder the girls makes Ron Logan's confession to Ricky Davis newly discovered evidence that would either be admissible through Ricky Davis, right? Evidence Rule 804B3, or through First Sergeant Hansard under the Due Process Clause of the 14th Amendment. Ron Logan's confession exculpates Mr. Allen and would probably produce a different result at a retrial, because I'm going to go back to what that juror said. And that juror kept saying, if not Richard Allen, who's Bridge Guy? Who else is Bridge Guy? Who else could be Bridge Guy? Nobody else could be Bridge Guy. Ron Logan could be fucking Bridge Guy. He lives right there. The girls were on his property. He lied about his alibi, when he did what, why, blah, blah, blah. Okay? And it makes way more sense, okay, that two girls, how you could subdue two girls is you don't even have to subdue them. Oh, hey, you guys want to come see the horses? Oh, yeah, right here. I have their property. I know your dad. Your dad's, what's his name? I know your mom. She bartends at whatever. Okay, yeah. So they're walking off, okay, to go see these horses and these rabbits, okay? And then it all got weird. And he panicked. Now, if that wasn't enough, we have number 3. I agree. I think Bridge Guy looks just like Ron Logan. I think he's got that walk of Ron Logan. He's got like that sway. Okay. He knows how to walk that bridge like the back of his head. You know what I mean? And they can say like, oh, Ron Logan was too old or this, that, and the other. Well, then you got to ask yourself who hangs with Ron Logan and if he trusted anybody to come and help him stage the crime scene. Number 3, Defendant's Exhibit 5, the affidavit of Stacey Aldridge. So Stacey Aldridge states that the dirt or water damage to the phone could not have caused the auxiliary jack on Libby German's phone to log wired headphones plugged in and wired headphones, unplugged. And this is so true, guys, because at no point ever was the testimony ever by the state that Libby's phone, you guys, it was never said, yeah, this phone had water damage because it went through the water and blah, blah. Like, that was never said. Okay. That was never anything that the state claimed. All right. They chose not to depose Stacey Aldridge. So they had no idea what she was going to say because Stacey Aldridge did not write up a report. And so literally, in a sense, the state went in blind, not knowing what Stacey Aldridge was going to say. Okay. So, and watch how this is worded because I think it's so well worded. So, and this is something that did not come out in the juror interview unless it's in like the edited part, but it was about the phone. So again, Defendant's Exhibit 5, the affidavit of Stacey Aldridge states that dirt or water damage to the phone could not have caused the auxiliary jack on LG's phone to log wired headphone plugged in and wired headphone unplugged. Ms. Aldridge's expert opinion is newly discovered evidence that would probably produce a different result at a new trial. So, because they never really got to talk about it. And you're going to see why. At trial, Mr. Allen introduced evidence through the testimony of Stacey Aldridge, a digital and mobile forensic expert, that someone plugged wired headphones into the aux jack of Libby German's phone at 5:44 p.m. on February 13, 2017, and unplugged it at 10:32 p.m. the same day. To counter this, remember, the state offered the results of a seat of the pants Google search by First Sergeant Cecil. Okay, the state offered the results. The state's phone expert. According to First Sergeant Cecil, the Google hearsay told him, in his expert opinion, the log on LG's cell phone showing wired headphones were plugged in to the auxiliary jack at 5:44 p.m. on February 13, 2017, and unplugged at 10:32 p.m. the same day could have been caused by dirt or water damage to LG's cell phone. The defense had no opportunity to counter First Sergeant Cecil's expert opinion, courtesy of Google. The court should read Ms. Aldridge's affidavit, Exhibit 5, in its entirety. But the short version of Ms. Aldridge's actual expert opinion is as follows. Nothing in the data on LG's phone indicated there had been water damage. None of the reports or extractions related to LG's phone created by law enforcement officers reflect dirt or water damage to the phone. You guys understand how big that is? Do you understand when you go back in the day when you'd go to like Verizon or you'd go to AT&T and you would be like, oh man, I got to turn this phone in, and I'm praying and I'm hoping that when I turn it in that they say, oh man, you got water damage. Like there's nothing we can't give you any money for this, you know? And so it's like, oh God, what are they going to say? What are they going to say? What are they going to say? You guys remember those days? Yeah. Well, an extraction would be able to tell you that. Remember those assholes that would be like, yeah, you got water damage here, so you're not going to get any money. You remember those days? Do you guys remember the days when Apple didn't cover water damage? So then everybody realized that don't go in there and say that you need to get a new phone because of whatever. Just say that somebody stole your phone. That way they can't take it and be like, oh, no, it's water damage. So, we don't cover that. That's when people start getting smart. Just go in there with no phone. So this would have came back in those extractions and in this report, like, hey, this phone's all damaged. And it didn't, because it wasn't. So it should have never been put into the jurors' minds that, oh yeah, it's water damage. That's why it did that. Like, that was an error. That testimony should have never happened. Yeah, you guys remember the red dot? I remember that too. Photographs of LG's phone taken by the Indiana State Police did not show the phone to be wet, dirty, or covered in debris, which is important because that's what fucking Nick McLeland was saying to those jurors. Unbelievable. Miss Eldridge's, quote unquote, is unaware of any scientific or technological research suggesting that water or dirt damage to an iPhone 6S would cause the phone to inaccurately log wired headphones in or wired headphones out. So basically, after, I want to know if this affidavit is new pertaining to this, and it's just like, hey, can you go and can you find out about all of this? And she's like, yeah, sure. So then she goes ahead and then, so all this new affidavit here is like, hey, this is what the experts say. Because that's the day that I said it's over. Like Richard Allen won was the day that Stacey Eldridge testified. I came out and I said it's over. Okay. The defense just proved beyond a reasonable doubt, by that terminology, that human hands handled this device. And it wasn't Richard Allen, right? Richard Allen wasn't out there then. Okay. Richard Allen was home sleeping actually when Kathy arrived at 5:30 that night. And Richard Allen wasn't out there at 10:44. He wasn't out there at 5:33. It just, and that right there, that's your reasonable doubt or unreasonable doubt for the juror that thinks it's unreasonable doubt. So that's the day that I came out and said that it's over. Like, it was her testimony. I was like, holy shit, damn, like the whole place in there like lit up. Like, damn, like Nick didn't go and just wild shit. Wild. I just sent you a link. There was a news report titled "Former Delphi Murder Suspect Made Detailed Confession to Killings." Yeah. Awesome. Don't really care about it. We got the facts here. We don't need their fucking bullshit. Those cheaters, line cutters. Can you guys believe that the line cutter interviewed the other cheater? I made a post about it. So according to the Apple Health data on Liberty German's iPhone 6S, the phone stopped moving at 2:32 p.m. on Friday, or on February 13, 2017. At trial, the state contended that Liberty German and Abigail Williams died close to that time, and that Abigail Williams hid the phone under her body before she died. The state also provided testimony by former Delphi Police Chief Steve Mullen and Indiana State Police Lieutenant disgraced Jerry Holman. There was no evidence that Richard Allen returned to the location where the bodies were found after allegedly being spotted by Sarah Carbon on 300 North at approximately 3:50 p.m. On February 13, 2017. If Miss Eldridge's actual Stacey Eldredge's actual expert opinion that wired headphones were plugged into LG's auxiliary port at 5:40 p.m. on February 13, 2017, and unplugged almost 5 hours later were credited by a jury, the state's narrative is impossible. Someone other than Richard Allen was handling Liberty German's phone multiple times long after the state contended Mr. Allen left the scene before 4 p.m. on February 13, 2017. Miss Aldridge's opinion that dirt or water could not have caused Liberty German's phone to log wired headphones being plugged into and being unplugged from the phone on February 13, 2017 exculpates Mr. Allen and would probably produce a different result at a new trial. Accordingly, the court should either vacate Mr. Allen's convictions or set this motion for hearing. I don't know how in the world anybody in America could read this and say to themselves, wow, this was in America? This trial was conducted in America? Wait, these prosecutors are American prosecutors here? Thoughts? Hidden true crime. I mean, everybody that's covering this case should be ashamed of themselves. The prosecutor should be ashamed of themselves. I mean, this is just... What's up, Teresa B? It just... Wow. Glenda, great shit. I love it. I just don't know how anybody could say that Richard Allen got a fair trial. I don't know how then you see all of this stuff and say to yourselves, wow, isn't the prosecutor of the county supposed to make sure that, I mean, like, that people in his town are hey, I'm running a fair ship here. Like, this is the United States of fucking America, man. Oh, van video. Thank you. Yep. Let's put that van video in. Lawyer Lee is live saying someone else confessed. I just talked about that. Yes, Layla. Yes, Ron Logan confessed allegedly to, yeah, there's a huge confession in here. And the confession to me, I believe, is either real or it is from somebody that knows the details of the case, like, extremely well. Like, when I say extremely well, that the killer basically told Ricky, whether that was Ron Logan or somebody else that fed him this information, Ricky 100% got the information from the killer. You understand? Does that make sense? So either really Ricky talked to Ron Logan and this really happened, or Ricky talked to Popo or somebody else that was the killer and say that Ron Logan, you know, and then for whatever reason, after Ron Logan died, why didn't the state just say, here, you know, the killer actually just died and here's all the evidence and this is what we're going to put forward and show, but we believe that we would have been successful in, you know, and boom. So I asked myself that. I'm like, why wouldn't they just do that? Save everybody's job, right? Then it's like, wait a second, how much money did everybody truly make off of this case? How much money? You know, fucking A. So here, let's Yeah, but I think number one's your best bet at that. Like, I mean, Brad Weber's van. Let's take a look at that Brad Weber bullshit. Here's your van. Ron Logan is dead. Exactly. Blame him after he's dead. Okay. They don't give a shit if he's dead, alive. But anybody out there saying that the girls got justice, fuck, then you don't know what the word justice means. Justice my ass. 15 tipsters said it looked like Ron Logan. Yeah, can you imagine if the jury was to see Ron Logan? I still can't believe Richard Allen was found guilty on such BS evidence. Yeah. Well, just, again, listen to that juror. It's pretty obvious that when you listen to that juror, why anybody, I would have been convicted of the damn crime. I mean, I wasn't even in Indiana at the time. You know what I mean? Fucking dumbasses. Fucking Kevin Greenlee would have been fucking convicted. His little, waddling ass bridge guy. All right, let's pull this up. Oh God, where's this van at? This damn van. This damn van. I have to type it in like this. What the hell? That's an under. Let's go like this. DI 6 PP B9 and Q. The video isn't available anymore? No way. Hey, Murky, can you send me that link? Do you have the link? I can't click the link. It doesn't work like that. Oh, hell. Yeah, I'm about to put in Michael Osbrook in there. I didn't want to I don't know if he wanted that to be out there, but. Oh. Filter. Channel name. There we go. I think the video's gone. Did he take the video down? You guys, I think the video's down. I just searched through his name. Damn. Need the video? I'm on his page. I wouldn't need it if I'm on his page. Right? He's got that little airplane thing, right? This is him. There you go. Isn't that his channel with the little plane? Oh, thank you. Is it unlisted? I don't know. Hold on 1 second. Did Michael Osberg take down that video? Because I can't find that video. Okay, he privated them, so I think we have them. Hold on. Michael, what the fuck? This is Tina's with the Fight Translation Services. Where is your video? None of you guys can see it. Oh, I mean, this case is a dumpster fire. I mean, if Nick McLeland doesn't get fired on the spot, I don't even know what to say. I mean, how any prosecutor could make it through this misconduct is, I mean, this is how this isn't a sanctionable, like, how do you keep your license, you know? And I don't even know what to say. How embarrassing. I cannot wait for the spin job, though. You know, they knew this probably day was coming. Man, I think you're on a roll. I would add another Marine into the mix. You know, I just don't want, I just think that just keep it right here. You know, Ron Logan does it. Ron Logan's reasonable doubt enough. Unless you're going to bring in Brad Holder because you're going to talk about Abby, you know, dating his son and things like that. But I couldn't trust a jury to follow any of that. I can't even get the damn jury to know what reasonable doubt is. They think it's unreasonable doubt. I was trying to get to unreasonable doubt. Okay. Awesome. That's my jury. I'm, you know, bad. Just bad day. Okay. Oh, God. Tell these hoes I said, step the fuck up, Caitlin Kendall. I work in LA. You gonna stay in Indiana, and I'll see what you're made of. Talk about this the day I bought and paid. Oh, yeah, I'm gonna. You guys, the line cutter, I have her ass. She interviewed Nick McLeland, so I put it. I was like, God, what a great day to see the line cutter and cheater interviewing the cheater. All right, we have the links. Here you go. Let me just send these to myself. Copy, cut and paste. Copy, cut and paste. All day, all we do is copy, cut and paste over here. No. Copy, cut and paste. All right, Michael, thank you. We'll take down your channel now. CCP in the house. You down with CCP? Yeah, you know me. Where is my Google? Let's see. Oh, fuck. Good news in the Kohlberg case, we will be live streaming public hearing. So that's good news. Oh, here it is. Okay, let's zoom it in here, folks. Gather around. We have a little thing to talk about. Here is this video. Okay. So 2:42 and 19 seconds. So this is 8 minutes and 26. So 2:42. So let's go to 2:44. Okay, it's coming. Oh, wait, hold on. It's right there. Let me make it bigger. And then it's all zoomed in. So this is like the actual footage, though. And so you want to look over here to like, I'm gonna send this other one. But just to prove that this is the actual footage. And then these are the zoomed in clips. We're going to zoom it in here in a second. Oh, boy. Fuck it, I'm just going to zoom it in now. All right, these are the zoomed in clips. You're going down. You're going down, McClellan. You're going down now. Tell me how you're down, man. Okay, here. So 2:44 and 33 seconds. And over here, that's right. You guys need to look over here to the left of the screen. You're going to see like this white house over here. You guys, this is the way that I went. Okay, so look over here where the little two white houses are, to the left of the screen. And then right now, in the left side of your screen, you're going to see like this vehicle moving. There it goes. Coming along, coming along, coming along. See? Come along, come along. There it is. Then it goes back in because you have to go straight. And when you go straight past, you're going down into Brad Weber's family's property. Now, this is zoomed in. Here are the two houses, so it's zoomed in. You're going to see, here we go. There's the cargo van. What do you got to say about this, Gray Pubes? I love it, baby. I love it, Gray. Now here's it zoomed in again. And even more, zoomed in 3. Look at that van. You guys are sick. What do you have to say about that, Greg? Gray, Greg, who knows? Who gives a shit? Whatever his name is. There it is. You guys, this is disgusting. This is disgusting. All right. There it is. So over here to the left, there she moves. Here she comes. There's the van. What do you have to say about this, Gray? How's this going to work out? Now, zooming in, it's going to come in closer here. Here you go. There's your two little boom, daddy, boom, daddy. Oh, hot damn. What do you got to say about this, Nick McClellan? We are looking at actual physical motherfucking exculpatory evidence. You know what I would do if I was Nick McClellan? I didn't even know this existed. I'm signing to get Richard Allen out myself. This is sick. What do you guys think? I mean, this is... I mean, you have this. This was given to the defense from the prosecution. Right here, the van. And it's going, because this person's house sits on this road right here. And when I went down there, I went a little bit down there in the vehicle, and then I was like, eh. And so I made like a right and came this way and turned around by those white fences, came back down this way. And I was like, wow, none of these houses have cameras, you know, to see if the girls would have went out this way in a vehicle. But there's the van coming home at 2:44. And then he gets on Wi-Fi at 2:50. Usually I don't condone name calling, but gray pubes got me. Well, when you're trying to mess with somebody's, I don't know, fucking freedom, I mean, pubes is the best name in the world. I mean, you can be called way worse. But here it is, guys. Why aren't you paying me all this money? I can watch this over and over and over and over. You know what, guys? If you guys don't start paying me, I'm gonna take this chat hostage right now, and this whole damn I'm stopping. There goes their star witness again. Now put this van with Brad coming out and me saying, Brad, why'd you do it? This is what I was talking about. He lied. He lied on the stand. Why'd you lie? Why'd you lie? There goes their star witness. Now, Walla, you got some explaining to do, girl. And now, wouldn't this just, if you were a juror, would this not like make your stomach turn? I would be so... like, I'd be throwing up if I was a juror. And let that slick back pony, Nick McClellan, lie to me like this. I would be like, what do I need to do? I can't sleep at night. And then if you know that they did this, then you know that they beat the fuck out of him in prison. You know that they did all these things. They did this. This exculpates the man. And they used it and they lied and they knew. They fucking knew this whole time. Oh, God. How this juror, like in Murder Sheet, RJ Benefield gifted 50 Truth and Transparency memberships. Holy ballsack. Great pubes would be showing you it all. Like, woo! I don't even know what to say. RJ Benfield. Wow, that's amazing. Wowzers. Thank you so much. That was really, really, God, who got a gift, man? I want to know who all turned green. The whole damn chat. That is sick. Wow is right. I'm like, wow. No, it's still in Gull's hand. I'm dead. Oh, color those pubes in the name of gray. Oh my God, I can't believe it. If I was a juror, I would be just like, They had this the whole time. They knew. They knew that Richard Allen couldn't have seen this white truck. Nobody could have seen this white cargo van. And you guys, it's a van. Like, it's the only thing that comes back there. And this is his street that goes, like, when I say street, the street ends up becoming his driveway. Oh my God, there it is. Oh my God, the cargo van. Why'd you do it? Why'd you do it, Brad? Now, ready for this? Just when I thought I couldn't get any sicker. Who's driving the van? Oh, just Brad Weber. Now, ready? Brad Weber is married to that story now. Want to show you the other thing that just made me like royally vom today. What the hell's her name? Indianapolis. Let's see. Where's this? God bless it. Oh, bullshit. Maybe it came down. Okay, here we go.
Abby Williams and Libby German in 20. Turn now to developing news in the Delphi murders case. Attorneys for convicted killer Richard Allen have filed new motions to try and clear their client's name. A jury convicted Allen in November of killing Abby Williams and Libby German in 2017. Now, the motion of errors filed today questions the timeline for these murders, with new video placing the white van that spooked Richard Allen before the murders at the crime scene 15 minutes after the murders. Now, attorneys also claim that Allen's Sixth Amendment rights were violated when his attorneys weren't present at an initial hearing in 2022. And the defense is also disputing evidence from Libby's cell phone after testimony claimed the state found someone was plugged into Libby's phone after the murder and that they didn't bring it to jurors. But the biggest bombshell revealed this morning, another jailhouse confession for somebody who attorneys claim was a prime suspect from the very start.
And Dan, all of that really revolves around Ron Logan, the man who owns the property where the girls' bodies were found. And this evening, Fox 59's Max Lewis breaks down what was allegedly said inside of that jail cell in 2017.
News.
The defense called it newly discovered evidence that is so significant and entitles Richard Allen to a new trial. It's a confession to the killings of Abby Williams and Libby German made by Ron Logan, who owned the property where the girls' bodies were found. The confession apparently took place inside the Newcastle Correctional Facility where Logan was serving his sentence for a
Look at him
probation
walking.
violation.
Totally
It's
Brit-
there that he got to talking with another inmate in his cell block, Ricky Davis.
Oh,
In a letter signed by Davis in June 2017, he recounted Logan's confession, writing, quote, "He told me he was the one who killed those girls, that it got out of hand. He walked with them in the woods to his property. The girls wanted to turn back and said something about calling the police." Logan apparently went on to say that he, quote, "grabbed the youngest girl to reassure her it was okay. However, they panicked and he also panicked." Logan indicated he ended up cutting the oldest with a box cutter. He went on telling me that he killed both of them because it was taken too far. At the time of that supposed confession, the fact that the girls' throats had been slit and that a box cutter was the likely murder weapon were not public knowledge. In fact, it wasn't until the trial late last year that the forensic pathologist who performed the autopsies testified that a box cutter was the likely murder weapon.
Now, looking back, they're able to say, well, with that box cutter information, that opened the door. Once they put box cutter and they had a suspect who confessed to using a box cutter, we definitely should have been able to get into at least this other suspect.
However, Judge Fran Gull ruled that the defense team could not put forward any theories about other potential suspects. In the early days of the Delphi investigation, Logan was a prime suspect, so much so that the FBI was able to secure a search warrant for his home. It's unclear if they ever found anything connecting him to the murders, but Allen's attorneys say that confession and the details in it exculpates Mr. Allen and would probably produce a different result at a retrial. Logan died of COVID back in 2022. The prosecution has yet to respond to these claims or any of the others made in these filings. Our legal expert told us that right now it is too soon to tell how or even if this will affect Richard Allen's conviction for the murders. In the newsroom, I'm Max Lewis, Fox 59 News.
Listen, if those jurors come forward, it would and will. Okay, so that's what I'm trying to say. This juror wanted to come out and speak. We got it right. No, bitch, you didn't get shit right. But now is your chance to be a freaking superhero. You want to go to law school? You could be a superhero. Your law school little legs and this little great career you want to have, this would be a great way in the door. Be a superhero. Now I want to show you guys a little interview that happened with that pretty pony right here.
Produced to the court. In this situation, this is the first time I'd worked with two other attorneys on a case. And so we would have open discussions about what is the best way to move forward, what is the best strategy for trial, what is the best witness order, those kind of things. So it was very much a group effort. It wasn't one person making the decisions.
We talk about public view and you talk about this case in general. I mean, it captivated.
Look at who was interviewing him. None other than the line cutter herself. The line cutter. The line cutter. That's her. The two cheats in the same room together, chopping it up. Of course they would be. Yeah, the down the hill comment sounded exactly like, I totally agree with that. Totally agree with that. And guess what? Ron Logan said he would repeat that. Remember he did that? Unbelievable. Unbelievable. You know, like,
so many people, not just from Carroll County, surrounding communities, state, really nationwide, so many people being interested in this case. And really, because of that, there's kind of been this whole like cottage industry, if you will, true crime people, interested in learning about the case, people just talking about the case, all the noise that's happening, whether it's after trial, before trial, standing outside of the courthouse. How did that impact you as the prosecuting attorney in this case?
You didn't stand.
You try to block it all out and try to focus, like you said, just on the facts of the case, because what happens on a YouTube true crime channel or, through the media, that doesn't really affect the case. You've got to focus on the evidence that you have and the facts of the case. And so you try to block it out. Now,
what evidence did you focus on, sir?
It's impossible to block it all out, especially when it's in your face, when you're leaving the courthouse. Obviously, it affected, I think, probably the family more than me, because there were some personal attacks on the family. I expect personal attacks as a prosecutor. I expect not everybody's going to like me. And so I kind of expected it.
This has nothing to do about liking you. Fuck like. Why does everybody use the word like? I don't give a fuck who likes me. But you know what? You're going to respect me because you're going to be like, oh, well, I go to Lana's channel and, the girl's not sitting there like giving us piles of shit and putting bows on it. Like, here, guys. Come buy a broken vacuum, man.
And didn't bug me. I guess you'd have to ask the family whether it got to them or not. I think some of the community members, it got to them because just so many people bad-mouthing Delphi as a whole in Carroll County and unjustly doing that. But for me, I just tried to block it out as much as I could and focus on, okay, what do we want to present at trial and what are the facts that we can prove?
How difficult was that for you to combat that? Here's what's happening in the courtroom and here's what's spreading like wildfire outside the doors.
I guess that's kind of a two-part question. For the pretrial phase, my concern was that we were going to taint any kind of jury pool that we had a hope of getting. And so that was my biggest concern, that we're not going to be able to get a jury pool that hasn't heard about this case or hasn't formed an opinion, because there was so much outside noise coming in and so many podcasts and YouTube channels.
Just so you guys know, I didn't speed them up at all. They were just so fucking stoned and speeding out of their minds. I'm just kidding. They're on 1.5 speed, just so we're clear. Okay. I sped them up. But can you imagine if they were just like, yeah, man, we just totally just ripped a couple lines, we're out of our minds.
And all these different things, we're reporting on it. And so pre-trial, that was my main concern. It didn't really affect me in terms of preparing for the case, but when selecting a jury, I was of the concern of, okay, are we really going to be able to get a jury that hasn't formed an opinion about this case already based on something they've seen in the outside world? And I've never dealt with a case that has much publicity as this, so there's a legitimate concern in this case. When you get to trial, again, I really didn't have a concern because the jury was sequestered. And so I felt pretty confident that they weren't getting all that outside noise. When we get to trial, my biggest concern was the safety of witnesses we had coming in the courthouse, the safety of the family coming in and out of the courthouse, and just then the safety of the officers working the courthouse and the grounds around the courthouse, because my concern was that a YouTuber, podcaster, or somebody else was going to fuel the fire for somebody who would act on those emotions and do something drastic, either intentionally mess up the trial, say something within the audience, cause a ruckus in the courthouse, put the officers in danger, put witnesses in danger. So those are my concerns with kind of the...
Wait, you thought we were going to do that? Why the fuck would we do that? What kind of fucking people do you deal with? Look at who busted his nose. His nose is the crookedest nose I've ever seen. Okay. Did he...
The outside publicity, not so much with the facts of the case.
You mentioned some of it about, sequestering the jury, pooling the jury, hoping that you're going to get a jury that, whether they've heard about the case, haven't heard about the case, but ultimately a jury that has no formed opinion. Do you feel Richard Allen had fair trial?
Yes.
How do you feel in terms of the sequestering process with the jury? Do you think it went smoothly, or how difficult was it for your team to cultivate that jury?
Well, we didn't have anything. I mean, we didn't have any responsibility with having them sequestered. That was all on the staff from Allen County. I think they did a great job because they didn't allow the jury to be contacted by outside sources, and they took all those necessary steps. So I think they did a great job. Once we started the trial, we didn't have any concern about them being sequestered. We trusted that the Allen County staff was going to take care of that. And again, we just focused on what we had to present. A lot of it is, it's not tunnel vision, but a lot of it is keeping your eye on the ball and just focusing on what you have to present and not getting caught up in all that. And so that's what we did.
Case had lots of ups and downs, I think, with anybody who was in there, I'm sure, for the prosecuting team too. Are you surprised that Richard Allen didn't testify?
What?
No, being a defense attorney for as long as I...
Are you surprised Richard Allen? The guy can't even sit straight. Is this... Okay. You guys don't know who this is? Yeah, me neither. That's how good she is. By the way, only 2,000 people, I think, have watched this. You're interviewing the prosecutor of one of the biggest trials ever to happen in Indiana, and 2,000 people have watched this. Okay. This was the girl that cut everybody. And ran inside. She's the reason that somebody that was waiting that you were supposed to didn't get into the courtroom. That's who's doing this interview, the line cutter. Are you surprised that Richard Allen didn't testify? What a stupid fucking question.
That's always the big question.
And he said no. Well, yeah, because you couldn't make it for him to testify. Because you made sure that he was handled up in those fucking max security prisons, man. Richard Allen will never be the same. And that's just fucking disgusting.
Are you surprised that Richard Allen didn't testify?
Are you surprised that Richard Allen didn't testify? Just curious myself.
No. Being a defense attorney for as long as I was, that's always the big question. Do you have the defendant testify? It's a catch-22. They have the absolute right not to testify. And if they don't testify, then you're relying on evidence either the prosecutor put out or that you can get out through other witnesses. If they don't testify, the jury is not able to hear them say, I didn't do it. And I think that's a big thing for juries to hear. On the other hand, if you have them testify, you open them up to cross-examination and open them up to oftentimes a lot of hard questions that are going to be hard for them to answer, which can make them look equally as bad in front of a jury. And so it's always, each case you have to look at individually. And so I wasn't surprised he didn't testify, but I wouldn't have been surprised if he did. We were prepared if he did testify with questions that we were going to ask him. But that's always a very tough decision as a defense attorney, whether or not you have your client testify. And you oftentimes have to make that decision in the fly. Is it going to help me or is it going to hurt me? And so we were prepared for either way they went. And so I guess I wasn't surprised, but I wouldn't have been surprised if he had testified as well.
Speaking of the jury, in your opinion, what do you think did it for the jury? What do you think was that tipping point to reach that guilty verdict?
Ooh.
I don't know. One of my pet peeves is when people tell me how I feel or what to think. And I'm not going to sit here and tell the jury, they should have hung their hat on this or should have made a decision based on this. In my mind, I would like to think it was just the totality of the circumstances, the totality of all the evidence that we had. And so I don't know if there was one specific thing. And again, you have 12 individuals who all have different life experiences and think differently. So what may have been the deciding factor for one juror may not have been the deciding factor for the other. One juror may have bought into or believed in the science of the ballistics. One juror may have said, okay, the timeline is what I hung my hat on. One juror may have said the confession. Yeah. In my mind, it was just a totality of everything that led to the conviction. But again, that would be a question for the jury. I don't want to try to tell them what they think or tell them what they should have hung their hat on.
When you hear that word theory really just being thrown out and about, as a prosecutor, when you hear the word thrown around, what goes through your mind when you hear this word theory thrown around the way that it has been?
Theory.
I've said this before, and I'll stick to it. It's okay if you want to use the word theory, but you got to back it up with evidence. And if you want that theory to become a truth, you got to have evidence to back it up. And we live and die by the burden of proof of beyond a reasonable doubt. And so if you can prove a theory beyond a reasonable doubt, then to me it becomes a truth in the court of law. And
yes, you fucking love it. What a dumbass bitch asking that question. And it's my opinion, First Amendment right, to say that she's a bitch. Yep, she cut everybody in line. She's a bitch. And she just asked an amazing question for us, those that are seeking the truth, because this man literally just was asked a theory. It's no longer a theory when you back it up. So his theory that the girls, and Richard Allen saw the van and then ran across the water with the girls, and 232, they're on the other side by that time, and because we got so startled, like right here, like this is just amazing to see this. Like all you people that are doing these interviews, woo, daddy.
Specific thing. And again, you have 12 individuals who all have different life experiences and think differently. So what may have been the deciding factor for one juror may not have been the deciding factor for the other. One juror may have bought into or believed in the science of the ballistics. One juror may have said, okay, the timeline is what I hung my hat on. One juror may have said the confessions. In my mind, it was just a totality of everything that led to the conviction. But again, that would be a question for the jurors. I don't want to try to tell them what they think or tell them what they should have hung their hat on.
When you hear that word theory really just being thrown out and about, as a prosecutor, when you hear the word thrown around, what goes through your mind when you hear this word theory thrown around the way that it has been?
I've said this before, and I'll stick to it. It's okay if you want to use the word theory, but you got to back it up with evidence. And if you want that theory to become a truth, you got to have evidence to back it up. And we live and die by the burden of proof of beyond a reasonable doubt. And so if you can prove a theory beyond a reasonable doubt, then to me it becomes a truth in the court of law. And until then, it's just a theory. That's just what it is. It's an idea of what you thought happened.
Yep.
And so I don't have a problem with people throwing that word around, but where's the
evidence? Theory.
There's been so much time where neither side had an opportunity to say much. It was under the gag order, obviously, for quite some time. What to you did the gag order mean? Gag
order to me was just a reiteration or a reemphasis on the rules of professional conduct that we're bound by. And that is that you should not put out anything in the public that's going to try to taint the jury or elicit a response from the public. And we're bound by those rules. And the gag order is just an emphasis of that to say, don't talk about this case in the public. Don't put out press releases that try to, condition the public to whether Richard Allen was guilty or innocent. And mainly that was done so that we can get a jury that's not tainted or biased. I really had a fear that we were, regardless of how many people that we subpoenaed in to be for jury duty, that we weren't going to find 12 that hadn't heard about this case. And so it was a real concern for me. And I wanted to be able to get 12 people who didn't form an opinion about this case, were unbiased, so that we could have a fair trial, not only for the state, but for Richard Allen.
And you felt like you got that?
Yes.
It's so easy these days, I think, to electronically disseminate anything. I mean, still to our newsroom, we get leaked crime scene photos, that photo that was leaked.
Sure.
You guys, this was chopped and edited. Everybody from the state and the juror did a cut, copy, paste interview. The defense attorneys are the only ones to date to literally do interviews that have not been edited. This is edited. Look, watch this. She cuts it, and it's a horrible edit job. Watch this right here. Watch this.
And so it was a real concern for me, and I wanted to be able to get 12 people who didn't form an opinion about this case, were unbiased, so that we could have a fair trial, not only for the state, but for Richard Allen.
And you felt like you got that?
Yes.
It's so easy these days.
Do you feel like you got that? Yes. And then listen to what she's talking about right here.
I think to electronically disseminate anything. I mean, still to our newsroom, we get leaked crime scene photos, that photo that was leaked.
Sure.
As the prosecutor, do you think there should be something in place to try to protect evidence like this? Or do you think that there should be a safeguard of sorts or anything to try to prevent things like that from happening?
I think the lawyers are the safeguard, both the state and the defense. I think we are the safeguard. We have an obligation to protect that confidential information and sensitive information that we get in discovery. I think we have to be the safeguard. Is there a better way to do it? Police it? I don't know. But I think we as attorneys have a responsibility, especially dealing with children.
Wow, I just can't believe that he wants his hair to be like that.
Children are victims of things, children's statements, photos of children, photos of the crime scene that involve children. I'm not saying that we shouldn't do that with photos of crime scenes that involve adults, but I think we have an extra level of care and duty to protect those things that involve children victims. So I think the attorneys are the safeguard. Is there a better safeguard? If there is, I don't know what it is.
Talk about why that's so important to you, because as a mom myself, obviously, I would never want photos like that of my child to be circulating. No one in their right mind would want to. Why is that so important to you to let people know, hey, this is not okay?
It was important at the press conference because I think that we've gone down this road with a lot of.
Well, guess what? Guess what is not okay? Okay. So I hope that you march your little skirt the fuck back in there and you ask, wait a second. You think this is okay? You think knowing that Brad Weber came home at 2:44 and 54 seconds or later, because by the time, like, this is him just entering into the driveway. Okay. And then knowing that the FBI report produced that his phone began to ping and began in that area at 2:50. Do you think that this is okay? That the jury went by your stupid fucking timeline of 2:30? No integrity. Keep throwing softballs. Keep talking about this over and over, these stupid fucking crime scene photo leaks. Okay? Unbelievable. Unbelievable.
Of the YouTubers and podcasters and even some media that it's all about how many people can I get to tune in or how many clicks can I get? How many followers can I get? And we'll do any means possible to get those followers, to get another follower, to increase that number. And that goes as far.
You will do anything for conviction. You will do anything for a conviction. Listen to him talk about YouTubers in his interview, like clicks and views will do anything. What are you referring to? Because nobody put those out on the internet. They were all passed around privately. Okay? Who put them out on the internet? Who did a YouTube channel showing the crime scene photos? Who was like, hey guys, come here and see these crime scene photos and pay me on my Patreon? No, I think only Zav Girl did that. And what case was that? The what's his name? Little boy. Fuck.
Down this road with a lot of the YouTubers and podcasters and even some media that it's all about how many people can I get to tune in or how many clicks can I get? How many followers can I get? And we'll do any means possible to get those followers, to get another follower or to increase that number. And that goes as far as showing a crime scene where, there's two girls that are dead, one of which is naked. And I just wanted to really emphasize that you can tell this story without those photos.
That's disgusting. And that wasn't done here. And that wasn't done on any YouTube channel that I've ever tuned into. Okay? Okay.
And whether you want to believe it or not, if you pass those photos on, you're part of the problem. And we can never, law enforcement did our best to scrub the internet of those photos when they were leaked. But it is an impossible task. If it gets sent to one person, like you said, it's so easy to disseminate stuff. Once it gets sent to one person and it's on the internet, if it gets posted on Twitter or Facebook or wherever, it's out there in the internet and you can never get it back. And so I was really emphatic about saying, don't use these photos to get more clicks or to get more readers of your story. Use something else. Because the only way, Becky Patty said, is generational. The only way we're going to stop those things from being, I guess, published through the internet is if we get people to stop sending them forward.
How did the heaviness play a role or a toll?
The line cutter asking these questions. It's also generational for Richard Allen. Okay. His daughter getting married and going to have a baby. And then he would be, a grandfather one day. So it's generational for Richard Allen too, right? Okay. Just making sure. Well, guess what? Delphi, Carroll County, this big oops that y'all did to violate my civil rights, because Richard Allen's rights are my rights. They're the American people's rights that you thought that y'all could fucking do. Whew! I'm here for it. I'm here for the ass licking that you're about to fucking endure. And I'm here for it. I'm here to report on it. But here is the lion cutter and cheater interviewing the other cheater.
And you as the prosecutor, I can't imagine the time and the hours that are put into a case like this on top of the heaviness of it.
Yeah, the time and hours, obviously we spent myself, Jerry Holman, Indiana State Police, my investigator, Steve Mullen, everybody
My
spent a ton of time
investigator.
trying to track down how the leak occurred. And then spend a ton
Why
of
are we
time
talking about this damn
trying
leak
to scrub
still?
the internet of those photos. And so it just takes, on top of everything else you're doing with the case. And so it is a huge amount of work to try to do that. The toll, I tried.
When was that before or after you were trying to figure out how you should use Brad Weber to fuck Richard Allen? When did you do that part?
Not to think about it much during the trial because you don't want to get consumed with emotion where you kind of take your eye off the ball. I think afterwards it hit me a little bit harder to think, okay, these pictures are still out there, and they're of these two little girls. And I think I have so much compassion for the family and how they feel when, I mean, people were sending them those photos and, you know, saying, hey, these are out there and those kind of things. So it really took an emotional toll on me afterwards because I started thinking about the family and kind of the words that Becky said hit home pretty hard, that it's generational. And, you know, just what I said at the press conference, what if it was your children? And so,
Yeah, no shit, it's disgusting. No shit, it's disgusting. That wasn't shown on any YouTube channels I watched, so I have no idea.
So during the trial, it angered me that those were out there. No reason for those to be out there. I don't care what.
Well, guess what? It angered me to see that you elicited false evidence and false testimony to railroad an innocent man. And so what do you think's worse, Nick? It's horrible that those photos were out there. Absolutely horrible. But on a scale of 1 to 10, the photos would be a 1 and you doing what you just did is a 10. But I get it. That's what you guys need to talk about, okay? Because that's the only little smudge you try to put up on the defense. And then I cannot believe Doug Carter putting blood on the defense's hands. Man, you claim that you're a man of Christ. Boy, God, Doug Carter. Judgment Day is not looking pretty.
A story you want to publish, you don't need those pictures to promote that story, in my opinion. And so it really angered me. And then afterwards, yeah, it's emotional to think, you know, I have kids too, and it's just emotional to think, you know, what if those are my girls? You know, what if they were pictures or my nieces or my sisters or whatever the case may be? So
Outside of the leaked photos, just the case itself. I mean, as a parent yourself, as somebody who has to go home and take care of kids,
sure,
it's challenging. I know the toll it took on me, not even just being home. I can imagine the hours that have to go into preparing for something like that. Caseload, generally speaking, outside of the leaked photos, can you share what that was like for you and how you navigated?
There are days you get overwhelmed and you want to just quit, and you know, because you have 2 or 3 things going on. You may have another fire to put on in the office, or another case came in that you have to deal with on top of the stuff for Richard Allen. And there are days, a lot of missed family events, and you just have to sacrifice that to put the work in that's necessary for the case. And so, you know, we're paid for 37 hours a week, and that's just what we are. You're not working 37 hours a week when you're working on this.
Wait a second. We were just paid for 37 hours a week. That's all we get paid for is 37 hours a week. And he's like, and I didn't work just 37 hours a week. Is he seriously only saying that he got paid 37 hours per week?
This kind of case. I do not know how many hours. I don't know that I want to know how many hours I put in on it, but a bunch.
Generally speaking, you talked about it, but how does one not take something like that home, the heaviness home? How does one not let it get to him?
Why do you care so much about his personal life?
You just learn to leave, I guess.
Are these questions for her or for the audience? Because I'm curious. Is this her like Tinder date? Swipe right? Like, what the hell is this?
It's that part at home. I mean, you think about it all night and all day when you're at home with your kids or with your family. You think about it. In this case, it was hard to get away with it get away from it because, you know, my family wants to talk about it. My friends want to talk about it. Everybody wants to talk about it, wants to know what's going on. But you kind of just have to be able to put it to the side and enjoy the time that you have away, because that's your time to recharge. So when you come back, you can, you know, work on the case again. So it's not easy, but it's just something you learn. I think probably all attorneys have this ability where they can kind of put those cases aside and put the emotion aside and, you know, still go home and enjoy time that you have with friends and family.
Waiting for the verdict probably felt like forever. I mean, people keep saying 19 and a half hours. It was more than 19 and a half hours. The jury was deliberating for 19 and a half hours, but there was time, obviously, that you're sitting there, you're waiting, you're wondering. Walk me through that time with you guys in the prosecuting team of the longer you waited. What was that like for you guys?
It's always hard waiting for the jury to come back. And I imagine if you took a poll of 50 attorneys, you'd have half that say, oh, it's better if they come back quick, and half that say they come back, you know, it's better if they come back or take longer to decide. I don't know, but it is, I guess, it's tough to wait. And it wasn't so bad the first couple of days. The Sunday that we had off between the Saturday and the Monday where the jury was off and we didn't have to come into court and we're just home, that was a hard day because you're just wondering, what are they doing? What are they thinking? So the waiting is always tough for me.
What are they doing? What are they thinking? Well, let me tell you, Nick, they were barbecuing with the freaking bailiffs. That's what they were doing. And then the people that were undecided, they were sent home to make charts, you know, of the evidence that you provided that was false. What a sick bastard.
It may not be for other attorneys, but it always is.
What a sick son of a
They do
bitch.
this right, they do that right,
This
but
is
I've
so
done this
sick.
I think you always do that. I mean, I can't tell you how much, but you're always going to second guess. Should I have done this? Should I have objected there? Should I have not put that in the evidence?
Should I have not done this? Yeah, you should have fucking railroaded Richard Allen.
Case, and I'm confident.
What should I have done? I should have railroaded Richard Allen. You know what? Looking back at it, I probably should have elicited that testimony from Brad Weber and acted like the van, came home at 2:30. Unbelievable. I'm just like, this is gonna go down in history. Like, I probably shouldn't even called Brad Weber to stand. Looking back at it now, this didn't age really well, this interview.
The jury's going to come back with guilty. I still wonder, should I have done that? Would that have been the thing they hung their hat on? Because you don't know at the end of the day what the jury's going to make their decision on.
When it comes to cameras in the courtroom, do you think that impacted the trial, or would it have been differently if there was cameras in the courtroom?
I don't know. I've never done a trial with cameras in the courtroom, so I can't really answer that question. I don't know.
Automatically going into this, assume that if you get that guilty verdict, there could be an appeal process?
Yeah, I think so, especially with a murder charge and the fact that the sentence was what it was. Even the minimum sentence on these kind of charges is 45 years. So I think in any kind of murder conviction, you expect an appeal. We expected it. We expected it from day one that if we get a guilty verdict, he's going to appeal it. And so, yeah, that's something we're ready for.
What is your role should an appeal happen? I know it's obviously been discussed. They're heavily saying they're going to do it. He's been appointed attorneys.
The Attorney General's office will represent the state of Indiana, and the Attorney General will appoint probably one or two attorneys to handle the appeal. Our role at that point, myself, Stacey Dean, or James Letchell, becomes more of a supportive role. Help them with any documentation they need to review. If they have questions about what happened in the courtroom or
if they have any questions, what the hell is this shit that I just landed on my desk? Can you explain this for me? Oh, what do you guys think? Wild. God. Two cheaters just chumming it up. The name of this episode is gonna change to Two Cheaters, One Cup. Y'all heard. Two cheaters, one cup.
How something was presented. We're there support for them to say what information you need. Let us help you get it. We know where that's at because we're the people.
Exactly. We know where that's at. Oh, I know where that video was. How the hell they find this shit? We had the dates all messed up too. Man, we had the time from 12. How did they figure out light time, daytime? Damn them. Oh, son of a bitch. And then I knew that damn FBI agent is the only person that could have brought something in. And then I did a really good job of, not stipulating to Zoom for that testimony. Fuck. Man. Damn. I am dead right now. What a fucking idiot.
Courtroom trying it and they're not. So we're just a supportive role.
Should an appeal go through? Do you prosecute it again?
When you say should an appeal go through, if an appeal goes through and the Court of Appeals says something was done wrong and it has to be retried, do we try it again? Absolutely.
You couldn't talk for so long. Is there anything?
Really? Easy, you ain't trying this case again? You fucking aren't probably going to be practicing law anymore. There is no way that this guy is going to be in charge of Richard Allen 2.0. You understand that, right? Like, that's not happening. That is definitely not happening. Yeah, let's just give it back into the hands of these fucking chums. No. Like, I don't know if Defense Diaries is still here, but tell me that this is not, like, how is this not possibly sanctionable by disbarment? I mean, what in the world? This is wild. And then, yeah, we're going to if it comes back to us, no, you ain't. Look at her. Look at how happy she is. Look at this fucking cheat. Oh, she was like, I cut everybody to get inside that courtroom just to see you, baby doll. Oh, man. Like, just the best day ever. This is Christmas morning for her.
Or want to say that you want people to know or take away from, whether it's this case or the impact it had on the community, or where do you go from here?
I don't know. I guess if I had to say anything, just thank you to everybody that helped along the way. And I always forget names, but Doug Carter, Jerry Holman, Steve Mullen, Stacey Dean, James Letchell, my staff, all the investigators, Rich Davies, all Brian Harshman, just
Right.
The list is endless. I said this the other day that I could not have done this by myself.
Exactly. You could not have done this by yourself. Brad Weber, that van, Monica Walla. I could not have done this by myself. Oh, but you did. You did. You outdone yourself. All right, guys. You guys have been great. Much love. Thank you again. Tippy, thanks for all your hard work and dedication, Lana. Again, brother Hector, you guys are awesome. Outstanding work you do, Lana. I appreciate yours and your team time and dedication to these cases with the purpose of reaching the truth. Yep, unorthodox as fuck, but we definitely try to reach the truth. And then 50 memberships went out. Thank you so much. If you turn green, make sure you let RJ Benfield know about it because he's the reason for the season. Oh, there you go, defensive. I'm here. What do you think? You think there's a chance that, I mean, would you, how would you not, this is sanctionable too, no? Would he be sanctioned? No, I don't know if you put something in chat. If you did, I'm sorry, I didn't see it. I can go back and look. I hate looking from StreamYard. Sucks. Half the damn chat gets skipped. Check out that comment, Anna, I was telling you about when you're done with this. What comment? This is the prosecutor. Yes, this is the prosecutor. These are the two cheats. I'm changing the title of my live. 2 cheats, 1 cup. Coming in hot. This is the cheater. This is the, who knows exactly, right? I mean, I don't know. I would think that eliciting false testimony is just unbelievable. Oh, God. All right, guys. Rock out with your cocks out. Jam out with your clam out. Do what you do. Thank you so much. Appreciate you.
Talk about one thing that you said. You stood up there and you said you weren't sure what kind of emotions you were going to feel today.
Yeah.
And talk about that. You pulled up and it just hit you.
Well, I got up really early today, and I didn't really work all day yesterday, and in my mind about what was happening, and I just decided to take the long way here. I was going to get here early, and I decided not to, so it was about a 2-cup trip, and I just disappeared into the rural areas of
2 cheats, 1 cup.
Delphi, from Delphi to my home, and it was a bit surreal. And then when I pulled into the parking lot, it was really surreal, and it was just peaceful. I just felt, yeah, weird. I didn't expect that.
Loved it.